Comparing and contrasting your obligation to medical treatment in an ERISA disability claim and a Social Security disability claim. Now, many ERISA disability policies or plans require that you get reasonable and appropriate medical treatment as a condition to continuing to get your monthly ERISA disability benefits. They also require that you apply for Social Security disability benefits. And so I'm often asked, well, is my obligation to get medical treatment under the ERISA policy or plan the same as it is in a Social Security claim? That's a great question. Now, I will tell you that the Social Security Administration rarely denies a claim on the basis that an applicant has failed to follow prescribed treatment and therefore is not disabled. However, I'll tell you in the context of a Social Security case that poor compliance with medical recommendations is often used by claims examiners or a judge when they're making a credibility decision, and that in turn can result in a claims denial. It's not that you are not necessarily following the instructions. That's not the issue. It's the lack of compliance that's the issue, and they make a credibility determination based on your lack of compliance. They aren't going to say right out, we're denying the claim because you aren't following medical treatment or recommendation, and if you were, you'd be getting better. What they say is, we just don't believe the intensity, duration, frequency of a person's complaints of pain or dysfunction based on the credibility determination they've made because of lack of compliance. And they'll use that, well, you can't be as disabled as you claim you are, as the basis for a Social Security denial. And in fact, Social Security regulations address these issues. Social Security ruling 96-7P addresses specifically the failure to prescribe medical treatment. And it suggests that an applicant's statement about functionality and symptoms can be less than credible if the level of frequency of treatment is inconsistent with the level of complaints, or the medical records or reports show that you're just not following the treatment recommendation, and there's no good reason for that failure. The ruling suggests that a judge or a claims adjudicator shouldn't draw any inferences about the applicant's symptoms or functionality without considering any explanation that the applicant might have, or provide any information in the record that would explain perhaps infrequent or irregular visits or the failure to seek medical treatment. And so under the Social Security rules, the judge and the claims examiner are supposed to consider this. I will tell you that in the context of an ERISA disability claim, they're not going to be as charitable. By that I mean they're going to look at the medical records to see if you've been compliant or not. And if you're not, they're simply going to say, you aren't getting reasonable and appropriate medical treatment. Too bad, so sad. You may not be able to afford it. Too bad, so sad. You may have had side effects because they aren't in the medical records. And they will deny the claim on the basis that you are non-compliant with the terms of the policy or plan, regardless of how disabled you are. So you can see that the Social Security Administration is a bit more lenient, if you will, than the ERISA disability carrier. But in both instances, I assure you that your credibility is being questioned based on your lack of compliance. If you have any questions about your rights to Social Security disability benefits or ERISA disability benefits, contact me today at 727-894-3188 for a complimentary consultation. I can help you regardless of where you live in the United States, regardless of who your disability carrier might be, and regardless of the nature of your disabling condition. 727-894-3188.